contrary to the fundamental principles of law.
Yes.
You can't excise 142.
गोधरा कांड के बाद हुए दंगों के 6 आरोपियों को सुप्रीम कोर्ट से मिली सुप्रीम राहत। पर यह एक चौंकाने वाली खबर है जो यह सोचने पर मजबूर कर देती है कि न्याय का तराजू किस ओर झुका हुआ है। साल 2002 गोधरा कांड के बाद पूरा गुजरात जल उठा था। निर्दोष लोग मारे गए, घर जलाए गए, चीखें गूंज रही थी, सैकड़ों केस दर्ज हुए, कुछ को सजा हुई, लेकिन आज 22 साल बाद सुप्रीम कोर्ट ने 6 आरोपियों को बरी कर दिया। क्या यह न्याय है या कुछ और? तो आखिर इस फैसले का मतलब क्या है? अब क्या हम मान लें कि 2002 में जो कुछ भी हुआ वह बस एक भ्रम था? क्या हम यह भी मान लें कि दंगे में मारे गए लोग सिर्फ हवा में उड़ाए गए थे? चलिए इस पूरी कहानी को सिलसिलेवार तरीके से समझते हैं। पहला भाग, मामला क्या था। गुजरात दंगों के दौरान खेड़ा जिले के महसाणा गांव में 17 निर्दोष लोगों को जिंदा जला दिया गया था। गवाहों ने कोर्ट में कहा था कि भीड़ ने पूरी प्लानिंग के साथ हमले किए। लेकिन देखिए मजे की बात, पहले पुलिस ने जांच की, आरोप तय किए, निचली अदालत ने 6 आरोपियों को दोषी माना, सजा दी, फिर हाई कोर्ट ने भी फैसला बरकरार रखा। लेकिन सुप्रीम कोर्ट आते आते सब कुछ बदल गया। अब ये जादू कैसे हुआ? दूसरा भाग, सुप्रीम कोर्ट ने क्या कहा। अब जरा सुप्रीम कोर्ट को सुनिए। कोर्ट ने कहा कि आरोपियों के खिलाफ ठोस सबूत नहीं मिले। अरे जब 22 साल तक सबूत इतने पक्के थे तो लोअर कोर्ट और हाई कोर्ट ने उन्हें जेल में रखा। अब अचानक सबूत गायब कैसे हो गए? क्या किसी जादूगर ने केस की फाइल उड़ा दी? तीसरा भाग, क्या सच में कोई गलती हुई थी? अब सवाल यह उठता है, क्या पुलिस ने गलत केस बनाया था? क्या लोअर कोर्ट और हाई कोर्ट ने गलत फैसले दिए थे? या फिर कोई ऊपर से निर्देश आया था? क्योंकि भारत में न्याय इतना सुप्रीम हो गया है कि जो गरीब होता है उसे चप्पल पहनाकर भी जेल हो जाती है, लेकिन जो सिस्टम के करीब होता है उसे सबसे सुप्रीम राहत मिलती है। चौथा भाग, राजनीतिक खेल या कानून का नया चमत्कार। अभी इस संयोग देखिए, यह फैसला लोकसभा चुनाव से पहले आता है। पिछले कुछ सालों में गुजरात दंगों से जुड़े कई आरोपी रिहा हो चुके हैं। इसी साल 21 बानों और बलात्कारियों को अच्छे आचरण का सर्टिफिकेट देकर छोड़ दिया गया। अब यह सब इत्तेफाक था या कोई गहरी प्लानिंग थी? पांचवा भाग, न्याय के तराजू पर सवाल। अब सबसे बड़ा सवाल यह उठता है कि क्या भारतीय न्यायपालिका से आम आदमी का भरोसा उठ जाएगा? क्योंकि अगर सबूतों के आधार पर ही फैसला होता है तो ये सबूत इतने सालों तक कैसे ठोस थे और फिर अचानक कैसे हवा हो गए? इस फैसले का असली मतलब। अब इस फैसले से 3 बातें साफ हो गई हैं। अगर आप ताकतवर हैं तो कानून आपके लिए अलग है। अगर आप आम आदमी हैं तो कानून आपके लिए सख्त है। अगर मामला संवेदनशील है तो उसका फैसला आने में 22 साल लग सकते हैं। लेकिन इन सबसे बड़ा सवाल, क्या यह न्याय है या महज एक राजनीतिक खेल?
As a principle of interpretation,
Yes,
you don't interpret a section by reference to another section in another enactment.
Certainly.
That's normally not done.
absolutely not. What I'm saying is sometimes it becomes a bit of a khichdi argument. We take some concepts from different ideas and put in a cocktail shaker and there out it comes. However, we have to have a conceptual clarity as to what the court can do, what the court cannot do, in which instance can the court do what it can do.
It can be argued if you look at 33, every attempt is made by the legislature to ensure that the award should, because it's one-step adjudication.
Yes,
Let's be clear. Arbitration is one step until unless they're two-tier arbitration. It's one-step adjudication, which has its drawbacks.
Correct.
One-step adjudication always has its drawbacks, and sometimes people don't like being put into one-step adjudication. But the legislature attempt is to ensure, even if it's a one-step adjudication, there should be corrective measures available to the parties, whether in form of 33, whether in form of 34(4), or in form of proviso to
I would submit that it is no part of the policy of the act to uphold an award come what may. Or this is not the IBC, and I've made that my note, where the policy of the act is always save the company, no matter what. The policy of the Arbitration Act is very clear, Millets, and that has been discussed. We can't start importing that just this is a policy or that is a policy. It has been judicially determined. Arbitration is an alternative to a very slow process of litigation that commercial parties often do not wish to have, because there is a economic cost involved even in delay. An expeditious decision, even if sometimes unfair, is possibly more acceptable to business than a correct decision, which will eventually take 50 years. Because parties cater their economic planning in a particular way. They have to plan also. If there is always a constant doubt as to whether an award will be upheld or set aside or modified, or this will happen, well, this will create economic chaos.
That is their argument, that suppose if the award is set aside
Yes, Milad.
and it is set back entirely,
Yes.
it will add to further delay, because the process will start from zero.
Milad,
If the power is exercised to vary it will curtail the further
that is
litigation.
the whole point. Milad. My lord assumes that it is in the rare occasion that a court will modify the award, and rather than setting aside and sending people back to the arbitration, rather than doing that, we'll just tinker it here. That tinker it here will no longer ever remain. Just tinker it.
Irony is, even where it was held that you don't have the power to modify, court is declared.
But that's under 142. And the wisdom of this court, minutes is given constitutionally by the framers of the constitution under 142. That wisdom that my lords have has not been.
If we go strictly by the principle of 142,
Yes, it is.
if it's contrary to the fundamental principles of law,
Yes.
you can't excise 142 to.
Well, it's the idea of that is subject matter for another decision.
No, that's settled now.
The SCBA's judgment, my lord knows. We all know the Supreme Court Bar Association, Justice Anand's judgment. That's true. But if at all a power is to be exercised, it can be exercised maybe by this court, partly because there will not be further challenge. That's on a lighter note. But the fact of the matter is, if this power of modification is given, rather than settling the matter once and for all by some court saying, all right, rather than referring you back, we will do it, that modification will happen in every instance. It will be a boon for the lawyers. That without doubt is the case. Whether it's so good for the clients, we are not so sure. So the remedy will be.
All that will happen is both parties will appeal under 37.
Yes, so rather than one
party
part,
setting aside.
there will be another round. First, there will be a round, on.
Anyway, there is going to be an appeal. So
there will be first appeal, on the question of as to whether you can modify or not. Secondly, there will be an appeal on whether it is curable or not. Third, once it is held to be curable or not curable, to the extent of being cured. This will blow a hole through the entire arbitration process, which has worked reasonably well for 30 years. Again, coming back to this, there have been instances of problems, I'm sure. But there have been instances of problems, as I said, with the justice delivery mechanism as exists currently with the law courts. It's not as though every judgment is correct by every court. You have appeals. Sometimes, and even a final decision is ultimately reviewed over the years later by the court. But that doesn't mean that just because there is a possibility of an error once in a while, we do greater damage without considering the consequences. This court does not have the expertise, with the greatest respect, to examine as to what will be the effect or the consequence of allowing modification power to be read in as a policy. The reason I'm making this argument in law is that the argument was made. If I just now go to my note, otherwise I'll be as guilty of having vague arguments rather than specific on. So the first was on adding words to the statute. Can't happen because the general law does not permit. Second, that it is not as though the statute is unworkable or unfair or unjust. It may result in certain injustices, but the statute works. And third, the general principle of adding words to a statute is well referred, to a violation of fundamental rights, where a statute is vulnerable by being contrary to some fundamental right. Article 13 says you will strike down that law. So the courts have devised a principle, ut res magis valeat quam pereat. Rather than striking down the statute, we will read it down, or we will insert words so as to save it from the vice of unconstitutionality. There is no such thing in a commercial statute like the Arbitration Act. No one has argued that because this is violative of a particular article of the Constitution and therefore is bad, therefore to save it from the vice of unconstitutionality, please read the words in. This principle is to be adopted, that you can start reading words in even without a threat of unconstitutionality. That will be a remarkable advancement or change, at least, in the law. That is not the law. For fundamental rights, you can do it.
What shouldn't interpret the provisions in a
As my lord
practical and pragmatic way to curtail further litigation?
Yes, Milind. That will come to the next point. I'm saying that Mr. Dattar's argument that please add such and such words explicitly made is explicitly incorrect for the following three reasons are given. So when the words cannot be added to the statute, then what? How does the power to come to modify? There are two principles that have been given, Milind. First principle that has been given is that the word setting aside itself means somehow modify. And the second is a theory of implied powers, that the greater power includes the lesser power. That's the two fundamental logical bases. So as regards the first point, as to the setting aside somehow includes the power to modify, there I only have to refer to the learned solicitors Black's Law Dictionary and Oxford English Dictionary. Setting aside means annulment. If there's any doubt in that, my lord will come to Hakim. Hakim has not been cited in some to some length, even though this is being reviewed. I just ask my lords to turn to Hakim and see how the learned division bench of this court examine this. My lord, that would be in volume 1 of our compilation, page 1. So the way will of course be aware of it, because my lord was part of this bench.
Solicitor's compilation also.
It's also in the solicitor's compilation. But
7 volume for all the
we made our compilation with all our side, so that there is no repetition, duplication. My lord wishes, we can refer to the
Give me the original one. Don't give me this one.
My lord can take the solicitor's volume. I'll give the paragraph numbers. Yes, please. My lord will take the solicitor's, and I'll use that. My lord will take the solicitor's compilation, which is, where is this?
और आप हमसे जुड़े रहने के लिए सब्सक्राइब करें YouTube पर, फॉलो करें Twitter पर और लाइक करें Facebook पर। और ज्यादा जानकारी के लिए आपको टाइप करना होगा सिर्फ न्यूज़ नशा।